General. First, let me say thank you to everyone here. This is a team effort as far as the state of South Carolina is concerned. I couldn't begin to mention all of the various agencies and folks that have been just great in helping us get this case launched, and I just want to personally thank all of you for what you've done to help us. As the General said, this is a rare case of the original jurisdiction. The original jurisdiction was established by the framers of the Constitution because conflicts between states cannot be really resolved except by a neutral and detached, objective fact finder and law giver, and that's the purpose of the U.S. Supreme Court here. What triggered this lawsuit, of course, is the application of the North Carolina Interbasin Transfer Statute, which purports to take it upon themselves to basically determine how much water can be allocated how much water in the Catawba River can be allocated by the state of North Carolina. So the only way to resolve that conflict, short of the efforts by the Attorney General to reach an amicable agreement or a compact, is through the United States Supreme Court. They stand there to resolve disputes between states, and that's what this is. The entry by Duke and by Charlotte and by the Catawba River Water Supply Project goes against the grain of the dispute between two states, because then that starts to insert private parties and to insert governmental entities below the state of North Carolina into the dispute. And that's why the U.S. Supreme Court has typically said there should be no intervention in original jurisdiction actions. It's for the two states to fight it out and let the best come out on top. But when you get all of these other entities in there, like we have now, then it just makes the whole situation difficult, expensive, time-consuming, and hopefully the U.S. Supreme Court is going to step in. It's very rare for the U.S. Supreme Court to take a case so quickly after it has appointed a master, because what they usually do is say, let the master have the trial, find all the facts, make all the conclusions of law, then bring the master's report to the Supreme Court, and then the Supreme Court says yea or nay on that master's report. In this case, we think we have a very good argument against the intervention of these three parties, because the U.S. Supreme Court has stepped in so quickly at the beginning of the case, not at the end, as those three parties argued, to say, okay, let the master find everything, make all the conclusions, all of that, and then decide whether we were rightfully should intervene at the end of the case. Well, the case is over at the end of the case, and we have gone through all of that when we think properly the intervenor should not be there in the first place. So this is a very good sign. We don't know how it's going to come out. We have to present to the Supreme Court our first brief on February 13th. The intervenors in North Carolina get a chance to respond in March, and then there's a reply, and then if the case, it could be that the case would be actually set for oral argument before the Supreme Court. That would be very rare, and that would be another good sign. They could hear this case at the end of April if they so chose to do that, and that's where that is.
That's on the intervention?
On the intervention. Yes. And that's a very, very important issue in this case. It may seem to some like it's sort of collateral and on the side and just much ado about nothing, but it really is important. And so we hope we can prevail on that. The special master's name is Kristen Lindsley Miles, M-Y-L-E-S. She is a private practitioner in San Francisco. She was appointed by the Supreme Court to be the master. And basically we have a conference call with her and all of the other parties once a month. In fact, we have one tomorrow. That will usually last at least 2 hours and probably sometimes as much as 3. The master, as General mentioned about the expenses, people don't know many times that the master has to be paid also out by allocations from the 2 states. And South Carolina paid its first installment to the master in December. The master actually ruled favorably for us in terms of her bill because North Carolina was trying to get another way of allocating the bill where the interveners weren't really charged for their portion of the case, but we prevailed on that, and the master first bill was paid in December by South Carolina's share, which was, I believe, about $72,000. She's been on the case, a little over a year, I believe. And so that's ongoing. We've got the intervention. We also are heavily into discovery in the case. Of course, a case like this is very complex. Tons of records, tons of depositions and interrogatories and requests for documents and all that kind of stuff that you see in a normal litigation. We have actually made 3 productions of documents. Charles Canny has been heavily involved in getting all of that. We've had to get documents from DHEC and DNR and some other places. Again, thank you for all your good work getting those documents that have been requested by North Carolina and the intervenors. But basically, that is ongoing as well. We're very steeped in that. Duke is making their production of documents to us. So is North Carolina, so is Catawba River Water Supply, and Charlotte. An interesting little twist to this case is that the master has seen fit to bifurcate the case. That means divide it into 2 parts. And the first part of the case will be South Carolina's burden to show an injury by the uses of water in the state of North Carolina in the Catawba River. That's the first threshold to get over. The U.S. Supreme Court has issued a number of cases in these equitable apportionment cases that require the complaining state, us, to show a substantial injury.